for joining us today during the conference and presentation of the 2 years report that is the fruit of 2 years research and analysis done by the team of the Ordo Iuris Institute. The report titled Children's Rights Pitted Against Children, the legal framework and practice of Barnevernet functioning in the perspective of international legal standards. The copy of the report is available for you. It is the preliminary version of the report. We will accept any comments and remarks during today's expert panel that will follow after the presentation of the report. And the final version of the report will be given and published next week in the book version and will be delivered to all the actors that are important for the Barnevernet reform or for the international child protection services, mostly in Europe. We are also very active in the field of the European Union law and the European Court of Human Rights, so we will also deliver the copy of the report in all the cases that are pending before the European Court of Human Rights. Let me introduce ourselves. In the very beginning, I am Jerzy Kwaśniewski, I'm an attorney at law and the president of the Ordo Iuris Institute for Legal Culture. And two of my friends, attorneys from the Institute, Bartosz Zalewski and Filip Wołoszczak, are together with me. We are the co-authors of the report. Not all of them, but some of them, because the report was developed in a huge team of mostly 8 people. And let me welcome Jan Aage Torp, who is together with us, our friend from Norway. From the very beginning, from the first day I arrived here in 2017, in August, when I started my research on the Barnevernet issue after 2 months of my cooperation with Silvia Garmo, who escaped to Poland after the Barnevernet tried to take over care of her little daughter Ira. A few words about the Ordo Iuris Institute. The Institute is an independent legal organization incorporated as a foundation in Poland and independent of any public funding or state funding in Poland or abroad. We are financed only by private donors, and that those are thousands of Polish families donating monthly to the development and the daily activities of Ordo Iuris Institute. Ordo Iuris Institute gathers academics and legal practitioners aiming at promotion of legal culture based on the respect for human dignity and natural rights. We pursue our objectives by means of research, other academic activities, as well as advocacy and litigation on national and international and European level. Third-party interventions by Ordo Iuris have been accepted by Polish and international courts and institutions, including, of course, Polish Supreme Court and Constitutional Tribunal, the European Committee of Social Rights, European Court of Human Rights. The Ordo Iuris Institute submitted its opinions and was asked for opinions by Venice Commission, the Secretary General of the Council of Europe, Commissioner for Human Rights of the Committee and Political Affairs and Democracy of the Parliamentary Assembly of Council of Europe. We cooperate with LIBE Committee of the European Parliament, with United Nations Human Rights Council. We submitted our opinions and written submissions to the Supreme Court of Brazil, Supreme Court of Croatia, for instance. The foundation is accredited to the European Parliament and registered. We are participating with our second seat in Brussels actively in the decision making and in the processes of law in European Union. Moreover, Ordo Iuris has an Economic and Social Council of United Nations consultative status in United Nations as one of few Polish organizations only. And for instance, our voice was to be heard during the Nairobi summit in November last year. Together with Jan Aage Torp, we were there. We were granted leave by the European Court of Human Rights to contribute our written observations in 16 pending Norwegian cases concerning Barnevernet in the European Court of Human Rights, and our written observations were submitted in November 2019, and in fact the written observations delivered to the European Court of Human Rights summarizes the results of our research that are also presented in the report. As I mentioned, we started our interest and research on Barnevernet and child protection services in Norway in 2017, but since foundation of Ordo Iuris in 2013, we are working with child protection services both in Poland and abroad, mostly in Germany, United Kingdom, sometimes the Netherlands and France. Every year, our litigation department supports 600 families in Poland in their cases concerning mostly child protection services in Poland. So we are aware that the problem of child protection services and the problem of striking a balance between the best interest of the child and the autonomy of the family is not only a Scandinavian, Norwegian, German, French, English or Polish issue. It is something that we have to deal all together as Europeans and representatives of the European circle of legal culture. In 2019, we have presented our preliminary results of the report during the roundtable of experts under the Chatham House rules in Oslo in January last year. The results and remarks given by the experts in Oslo, the experts on human rights, were also taken into account while drafting the report. The first version of the report was consulted during the side event organized in the Parliamentary Assembly of the Council of Europe in Strasbourg in June 2019. Our report may be summarized in one general observation, pointing to the source and the gravest error of the Norwegian Child Protection Service, Barnevernet, the departure from the fundamental principle of family reunification in all cases where the measures of last resort, separation of the child from its family, were implemented by the authorities. European Court of Human Rights noted that regard for family unity and family reunification in the event of separation are inherent considerations in the right to respect for family life under the Article 8 of the European Charter of Human Rights. Although national authorities enjoy a wide margin of discretion in assessing the necessity of taking custody of the child, this discretion is not unlimited, as the tribunal underlines. The discretion is more restricted when we are dealing with fundamental rights. Such rights unquestionably include the right to an undistributed family, undisturbed family life and parental contact, with the right to raise one's own biological children. Even in 1988, the court confirmed that in fact exercising parental rights itself constitutes a fundamental element of family life. So those are two sides, the best interest of the child and the rights of the parents joined together into the family life autonomy and the family life respect. That is one of the fundamental rights. And also one of the fundamental rights of children at both the international level of their protection and the legal systems of many countries is the right to live and be brought up in their biological family. In the preamble of the Convention on the Rights of the Child, to which Norway is also a part, of course, and as you may not know, the Convention on the Rights of the Child was firstly drafted in Poland in 1970s by Professor Smyczyński, and afterwards the works in the United Nations were also led by Polish lawyers in the 80s. And according, in the preamble of the Convention on the Rights of the Child, it is clearly stated that the child, for the full and harmonious development of his or her personality, should grow up in a family environment. The state has also a positive obligation to make measures to facilitate family reunification as soon as possible. This is why the European Court of Human Rights pointed out in Strandloben that in the case of imposition of public care restricting family life, a positive duty lies on the authorities to take measures to facilitate family reunification as soon as reasonably feasible. And this is the general observation of the report, that the Norwegian authorities, in their policy of foster care, in their policy of child protection services, have departed from this basic fundamental element of the Article 8 of the respect for family life, the need for family reunification. And what are the results of this departure? Long-lasting separation, fast-track adoption procedures easily done without consent of the biological parents, discrimination of minorities, ethnic minorities, religious minorities, national minorities, children being deprived in many reported cases of their fundamental rights to self-development in line with their national religious language identities, lack of cooperation with parents who need support after the last resort measure has been implemented, non-transparent cooperation and personal connections of Barnevernet, Bufdir, and private companies managing the foster care families, and many reported informations by the experts, by the Norwegian experts also, that there are many foster families dependent in their income on their foster family status. That itself creates a group of interest in the system. Therefore, in the opinion of the Ordo Iuris Institute, public authorities should always rely on the presumption that the child's best interest is best served with his or her biological family, and any doubts shall be resolved in favor of the parents. And only if there is a substantial and credible evidence that contradicts this presumption, public authorities should endeavor to preserve child's interest outside its biological family. Even so, the state shall continue to attempt to re-establish the sound relationship between the child and its parents by appropriate measures such as regular contact visits performed under supervision of social service workers and unsupervised meetings as well, psychological assistance to both parents and their child, and reports prepared by independent experts, with the special stress given on the rights of the minorities and with the special stress granted to the rights to the identity of the child, ethnic, language, religious, national identity of the child. Parents should be given the opportunity to change their destructive or in any other way unacceptable behavior that led to the separation, and to improve their care skills in order to prepare reunification with their child. In other words, in the opinion of Ordo Iuris Institute, Article 8 of the Convention should be interpreted by the Norwegian authorities as a right to a second, a third, a fourth, and a fifth chance for the parents to reunificate with the child, and for the child to reunificate with the parents in the biological family. Now we'll follow with the brief presentation of the parts of the report. The report itself is given to you, so you can read all the details given in the report. Bartosz Zalewski will present the general structure of the report, and then we will follow with the short presentation on the general results of the proceedings in the European Court of Human Rights given by Filip Wołoszczyk.
Thank you very much. So, ladies and gentlemen, it's a pleasure to present the first comprehensive study about Barnevernet practice and the legal frameworks in the perspective of international law standards. I think that it's also valuable that it's prepared by independent, non-governmental organization. We analyzed legal regulations, their interpretation, their implementation, and finally consequences of this situation for children and parents' rights. For our research team, the statistics and case studies were equally important, because only that way we could describe the whole system from the perspective of human rights. Firstly, I would like to briefly describe the course of works over the report. They have started in early summer 2018 and they took about 18 months. We sent 3 requests for information to Bavdir and 1 to Norwegian embassy in Warsaw. We also organized 2 expert panel discussions on the report, both in Oslo and in Strasbourg, during the session of Parliamentary Assembly of Council of Europe. And we read dozens of judgments and documents. To my surprise, I have to say that data collection was one of the most difficult tasks. Contrary to our presumptions of transparency of Norwegian authorities, research requests submitted to Bavdir were ignored for long months, as you can see on the slide. Cooperation with Norwegian embassy in Warsaw was much easier, but embassy officials had no access to any data which we couldn't find ourselves on websites of Bavdir or Statistics of Norway. After this preparatory stage of works, we organized a research visit in Oslo. It took place in January 2019. The roundtable of experts, lawyers, Norwegian and European politicians, as well as social activists who were engaged in cases connected with Barnevernet was held under Chatham House rules. Our invitations to the expert roundtable sent to the authorities, both Children Ombudsman and to Bavdir, were ignored. The protocol from this discussion is enclosed to the report as the first appendix, so you can read it. We also had a meeting with parents whose children were taken away by Barnevernet, and we held query in the library of the Faculty of Law at University of Oslo, where we have found very interesting materials which are not available in Poland. So as you can see, we use different sources of information which make our report unique. In May 2019, we were ready to organize presentation of a preliminary draft of our report on the side event held during the session of Parliamentary Assembly of Council of Europe. Together with author of Parliamentary Assembly's report on Barnevernet, Valeriu Bileci, and Ukrainian member of PACE, Pavlo Hungarian, and also president of European Apostolic Leaders, our friend Jan Aage Torp. This discussion was open to public, and each member of parliamentary delegation could take the floor, but no one from Norwegian delegation appeared. Next months were very important. When our work was coming to the end, European Court of Human Rights issued a judgment in the case of Trude Strandloven. As we know, the court held that there was a violation of Article 8 of European Convention on Human Rights, and this judgment confirmed many of our of the arguments articulated in our draft report, as were presented before in Strasbourg. Now let me briefly describe the structure of our report. So it consists of 6 chapters, preceded by a description of the main 29 conclusions and recommendations. First chapter has an introductory character. We describe Barnevernet in historical perspective and shortly indicate our methodological assumptions. Next three chapters consist of description of substantial conditions for depriving parents' custody over children, foster care, and procedural issues. Fifth chapter, which I think is very important, is connected mostly with rights of children from national, ethnical, linguistic, and religious minorities. In the last chapter, we describe how Barnevernet is perceived by selected domestic and foreign media. At the end of the report, you will also find two appendices. The first one is the protocol from our meeting, as I said, and the second one is a small dictionary of basic terms, which could be unknown for many people even here from Norway, like bavdir, etc. As you can see, our study presents all issues connected with child protection system in Norway. So in comprehensive way, these issues are presented, and they are presented from different points of views. We can also define some of the main problems of child protection system. Firstly, protection of children's rights in foster care, which are not sufficient. Only for example, there is no prohibition for separation of siblings. The best example is the case of Bądź family. As we know, in 2015, 5 children were taken away from their parents, and they were placed in 3 different foster families. And according to a resolution of Parliamentary Assembly of Council of Europe, entitled Striking a Balance Between the Best Interest of Child and the Need to Keep Families Together, siblings shouldn't be separated during placement in foster care. The second crucial issue is that in Barnevernet, there is only one regulation dedicated to children from national or religious minorities. They are usually placed in foster care of people of different culture, different language, and faith, which is very dangerous for their identity. The practice of not taking into account the foster family's ability to ensure the child's identity may also be considered as discrimination. There are no statistics which would allow verification of to what extent the group of foster families reflects the current social structure and takes into account ethnic and religious diversity of population of Norway. That is very significant. This is so important issue, and there is no available statistics and no statistics collected by Bądź. We asked about them, and we received answer that they do not collect such data. And according to Parliamentary Assembly resolution, religious, ethnic and cultural background must be taken into account when child is placed in foster care. Another important issue are rights of parents. Here the biggest problem are contacts of biological parents with children placed in foster care. 3 or 4 meetings per year, which is not uncommon in Norway, must be considered as the violation of the right to protection of family life. It was confirmed by judgments in Jansen and Loben cases. The analysis of the case law of Supreme Court of Norway and the examples of judgments you can see behind me lead us to clear conclusion that the limitation of parents' rights to have contact with their children for only a few short meetings a year is fully accepted in Norway. We also found out that there is no sufficient regulation to prevent unclear relations between private care institutions and Barnevernet. In last years, about 3,000 children were placed in such institutions, so we can see that it is the issue of great importance. It's also known that there is a flow of employees between such institutions and Barnevernet, and this can lead to various types of irregularities. Some of them were described by media. There are also many problematic issues in practical application of Barnevernet law. Section 412, which is the legal basis for taking children away from parents is interpreted in arbitrary way. Moreover, we observe tendency to redefine the principle of the best interest of the child. Many of the Barnevernet activities seem to implement the alternative principle formulated in the OUA report of 2012, the principle of the optimal development environment without due respect for self-standing value of biological bonds. This approach is an obvious violation of the human rights principle of respect for family life. And it was reaffirmed in Strand Law and Judgment. European Court of Human Rights once again confirmed that personal ties between natural parents and their children must be preserved as long as there are no exceptional circumstances. After placing children in foster care, families should be reunited as soon as possible, and it is also in the best interest of a child. Also, measures used by social services must be proportionate to the situation. Emergency orders are extraordinary measures which shouldn't be overused. In recent years, we could observe tendency to issue almost as many emergency orders as regular decisions. What you can see on the diagram behind me. According to data presented in documents of Parliamentary Assembly of Council of Europe, in 2015 there were even more interim orders than regular decisions. And we have to remember, each interim order must be confirmed by regular decisions. The question, why there was more interim orders? Unfortunately, this data, and we know that from BAVDIR, are not collected since 2016. This is symptomatic because these data are crucial for understanding the deficit of Barnevernet system, and they were stopped to collect just after the case of Bodnariu family. In conclusion, Norwegian child protection system needs a structural reform. This could be done by amending the law and elimination of provisions which can be interpreted in an arbitrary way and used as grounds for placing children in foster care. Introduction of mechanism which would oblige Barnevernet to fully examine all circumstances which might justify an intervention regarding family life. Better verification of all notifications, and of course full participation of parents and children in all stages of procedures. We also think that there's a real need for reform of educational system of social workers. The axiological basis of the whole system must be changed. We could say that Norwegian society is standing in front of some kind of philosophical questions. What is better for future generations? Omnipotent state, as we know from, for example,
jurisprudence of the European Court of Human Rights.
Thank you very much. Ladies and gentlemen, as you all know, for some time, international criticism of the Barnevernet system has been arising more and more. It is manifesting in very broadly. For example, starting with Valery Gileci report adopted by Council of Europe, granting the asylum of Celia Garmor in Republic of Poland, Ordo Iuris presentation in the Council of Europe that took place last year in June, our OBWE presentations concerning Barnevernet, and finally the case law of European Court of Human Rights, which in his recent judgment indicate what systematic definitions it can find in Barnevernet system. In our opinion, it is very encouraging that in 2 months of last year, from June to August 2019, 20 new cases were communicated by the European Tribunal of Human Rights to government of Kingdom of Norway. All cases concern Barnevernet system and the breaches of human rights, especially Article 8. In 16 of those cases, Ordo Iuris sent amicus curiae opinion, and in 8 of them we have applied for a consent to present that kind of opinion, and we are still waiting for the consent to be granted. At this point, I would like to present what conclusions can be made and can be drawn from the rulings of European Tribunal of Human Rights concerning the Barnevernet system. First of all, as the biggest sin, it has to be stated the concept of the good of the child adopted by Barnevernet system. The Norwegian state emphasizes material issues of child development. It can be found in the report that the percentage of the children picked up from the unemployed families or families where the parents are performing physical work. Children took from these families are 7 out of 10, so very big percentage in our opinion. And the system omits the basis needs of the child, which are elementary of the proper growth and development of the child. As a consequence, the values arising from the deep bond between the child and biological parents are totally abandoned. As a result, the recognition of the family as a value itself is also abandoned, and consequently the family and its interest is not taken into consideration at all. The issue of a faulty recognition of child's good entails further weaknesses in the system. The consequence of this is separation the good of the child from the good of the parents, and the omission of the family as a whole, as children and the parents. Therefore, the tribunal criticized the Barnevernet approach of denying of importance of maintaining emotional ties with biological parents, and in return taking account of contacts between the child and biological parents only on the plane of knowledge about children's origin. Because of this, contacts are established in a way that do not ensure the parent-child relationship is maintained. The court emphasized that it is in the best interest of the child to maintain all links with their biological parents. In addition, widely criticized are also solutions adopted by Barnevernet. As the principle of the European Tribunal of Human Rights, it is accepted that separating child from the parent should be only temporary and exceptional. This assumption imposes a number of positive obligations to the state. The state, in the first place, should strictly monitor the application and implementation of measures which consist in separating children from the parents, where the reference point to that should be the right to respect the family life as it is indicated in Article 8 of the Convention of Human Rights. Measures that break the bond and are not aimed at returning the child to the family should only be used in very exceptional cases. The state is obligated, therefore, to take, in the first place, a number of measures to prevent taking the child from the family and to repair what the system thinks it is not working in one family. It should first use measures that interfere less with family autonomy, taking account the principle, as it was said before, of subsidiarity. In case of taking away of the child, as I mentioned, it should be temporary, and this another positive obligation of the state is to do everything possible to reunite the family, to stop the taking children into foster care. Therefore, the European Tribunal of Human Rights negatively assess activities involving the automatic removal of children from families and setting up a foster care system that assumes long-term and no remedial proceedings. That is due to the fact that the tribunal recognized the bond with a biological parent, and the children maintains in the biological family as a value itself, and it emphasizes that it should be protected, because being in the biological family is strictly connected with the child's best interests. This is the best interest of the child to be brought up in a biological family. And what is more interesting, this is not jurisdiction of European Tribunal of Human Rights, but it's district court in Warsaw, which is very strict to that last time. The court in Warsaw, in the last case that we were helping in, did not let extradite citizen of Bulgaria to Norway, because court decided that here in Norway, according to jurisprudence of European Tribunal of Human Rights and Consul Kowalski statement, that his human rights can be violated here. So as we can see, the criticism of the system that we can hear on the international grounds can be heard also in daily life, as we can see. And let's hope that all new 24 cases will be maybe a spark for the government to change the system in favor of families and children, to protect their best interests and rights. Thank you very much.
Thank you very much. I will just add that, yes, of course, we have seen that the verdicts, the decisions of the Polish courts that refused to give over citizens of Norway or a citizen of Russian Federation who escaped from Sweden to the Scandinavian countries because of the risk of the violation of the basic human rights of the Article 8, the respect for family life. And that was done under the regime of the European arrest warrant principles. So we can see and we experience the results of this criticism of the human rights violations in northern European countries. And going back before 2015, 2016, where this debate started on, we can observe, and it was observed in the doctrine of law, of the family law on the international level, that we have at least two models of the child protection services active in Europe. This southern and northern model, with the different position of the family in the structure of the state, with the principle of subsidiarity in the southern model, where the family is the prior and basic structure of the society that can be assisted by the state, but that can be influenced only in the situation of the violation of the basic needs of the child. And we have the second model, the northern European model, where the state takes over the responsibility to bring up children and grants, in fact, the possibility to grow up the children to the family, and takes over and implements all the control tools to evaluate how is the family doing in the execution of this obligation. In the last years, what we can see in the European Court of Human Rights, in the Council of Europe, with this resolution of June 2019, drafted by Valeriu Ghilecki, is that the southern model of subsidiarity is taking over and is implemented as the binding implementation of the Article 8 and the respect for family life. And what is the outcome of this debate that is already over after the Strand-Loben case and other cases in European Court of Human Rights? It is the need to reform the northern model in the states that have implemented the northern model of the child protection services. And elements of the northern model of child protection services were implemented in many European countries, not only in Scandinavia, not only, and we all need to work on that, finding out the best solutions to strike the balance, as it is said in the resolution of June 2019, between the best interest of the child and the need for family reunification and the need to protection of the family life. Jan Aage, I would like to ask you for the comment, the first of the comments today to our report. We were working together since the first visit in Oslo concerning Silje Garmo case, and this preceded our research and work on the report itself. But you were on each of the stages of the work on the report together with us, and I'm very curious on your remarks and opinion on that.
Thank you so much. Thank you for a splendid presentation. Just on a ceremonial and honor note, you, the three of you, plus Dr. Sich and the others involved in your team, have done such a tremendous job for our nation and for other nations as well. One of the things I really appreciate is the thoroughness and the quality of your work. Even the report is so nicely made. I mean, you're obviously putting a lot of resources into this. And when you choose a place to have this presentation, although competing with governmental shiftings in Norway, you choose the most expensive place available, which to me speaks volumes about your respect for Norway, your respect for our institutions and our culture. So that I really appreciate. And I'd like to, on behalf of Christian Coalition, which I'm the chairman of, I'd like to give you a small token of something that maybe I'm not proud of every aspect of the photo pictures on this, but it's certainly something that we really love as Norwegians. We like to be the rascals. We love to be the Vikings, the hordes that take the world, sometimes in not so good ways. But here is a little reminder for you when you have your cup of tea or coffee.
Thank you very much.
Here's a little reminder for you.
Thank you very much.
And here's a little reminder for you. And tough luck, Dr. Sich is not getting it because he's not
Thank
here.
you. Thank you very much.
Thank you. Let's give them a little applause if you don't mind. I think reading again through the report yesterday, it strikes me how challenging it is, and its professionalism, and its compliance with international standards of law, and the clarity with which you present your arguments. Now, I remember when you presented the first version of it 1 year ago here in Oslo, how it was, and of course it has developed since then. But really, looking now 1 year later and 2 years after you started, you've already won. The thing is that this primer, should be a primer in Norwegian Barnevernet or similar institutions of training in the future. I believe something will come of that sort. But you have already laid a framework for our country and even for the international standards. The international judgments on Norway. So this is a really remarkable work that identifies the problems, analyzes them, and presents solutions. I think one thing that that we need to appreciate is that although your work is remarkable, and also like Alliance Defending Freedom in both Strasbourg and Vienna and London, etc. Probably the greatest reason why we're winning so many cases now in Strasbourg is the combination of Dr. Valery Gilecki's report, which was thorough, and he talked to all sides. By the way, I have heartfelt greetings and congratulations from my close friend, psychology specialist Einar Salvesen. He's on vacation with his wife in the Canary Islands and is smarting to want to be here instead, but he can't. But he really acknowledges your work. Dr. Gilecki met with Salvesen and other experts on our side and saw the flaws. And he, by presenting that case for PACE and getting such a massive result in PACE, which could have been even more actually had the Polish representatives actually been there and voted. And the Romanians, they stayed home because they were busy with other things. So, I mean, it could have become 85%, you know, if we had really mobilized. But Dr. Gilecki laid the framework, and he helped me understand that what PACE passes as a resolution becomes an important premise for the Court of Human Rights. So that, I think, is a very important thing. The other important thing is, which also Dr. Gilecki was fundamentally involved in, is that because he was the chairman of the Judges Selection Committee in Strasbourg, when the former Norwegian Supreme Court or European Court judge had to leave his office, the new appointee was discussed by Norway, and they presented many suggestions, but none of them were accepted. Finally, Dr. Gilecki and the committee found 3 candidates that were acceptable. And we were personally involved also in interviewing the candidates. Dr. Arnfinn Bårdsen, who won the vote, Dr. Jørgen Aall, who would have been a very able judge from Norway. But when Dr. Bårdsen, who probably does not agree with Ordo Iuris, nor any of our environments, he saw the need to take this seriously. And I did not realize that until then, in 2019, there were just a few cases from Norway that were accepted. And why? It's simply because the justice from a nation has the sole power to okay that a case comes through. And the former justice was not okaying it. But Dr. Bårdsen okayed it. So that's why we got a rush here that came through. So there are some converging factors that are very important to understand why we're seeing this going on and why your work is so relevant right now and is a tool in the hands of the courts. Now, the actual content of the report has been very strongly presented by you, and I'm struck by your sensitivity to how to get this across in the Norwegian setting. Showing respect, you're strictly professional and academic in your approach, which I think is wonderful. And I think that because of that, there's a chance that it can reach the minds and the decision processes of the courts in Norway, and even finally into Barnevernet itself and the political institutions. But I think there's some work that needs to be done now with this report. If I may suggest, and again, it's going to cost you a lot of money, which you've already spending a lot of to help Norway, I think you have a big task to do with the church in Norway. Not just the Roman Catholic Church, but the other churches in Norway. Apart from myself, I don't think there's one single pastor in Norway except my good friend Jan Aage, who owns TV Vision Norway, who actually is involved and speaks strongly on these matters. And I think there's a huge potential by having seminars conducted by Ordo Iuris, recruiting some experts from Norway to present this for the various churches in Norway, which are all a part of the so-called, what you call the northern model, which in Norway tends to be called the Norwegian model. And the whole church has accepted this model, which is fundamentally a Marxist-Leninist model, which comes out of the old communist regimes. I have this from my good friends in the various embassies in Oslo from the Eastern Bloc, the former Eastern Bloc, who tell me that this is the way we were thinking before. And this has been implemented in Norway and is subtly made a part of the so-called Norwegian model. The church has made this a part of our existence, and we have to shatter that. I still remember when I have been married once before, and I remember my first marriage, how my ex-wife suggested that maybe we should become foster parents, because that would be like a missionary task. And that has been the way we have presented in Norway in the Christian movement, that being foster parents is really like being a missionary, taking care of the homeless and the needy children, without really thinking through the fundamental need for family and biological family and the connection between the wider family. So I think there's some work to do here of fundamental nature. I would also encourage you to go to all these church bodies. You will find it will be a stiff uphill battle, I promise you. Even in Norway, the Roman Catholic Church is in no way of the same standards as the Polish Roman Catholic Church. I humbly submit this. And my own Pentecostal movement is still absolutely not that way either. But I think you have a lot to gain there. The other aspect that I think is really important now is to work constructively with the legal profession. Personally, I'm making now a television show for TV Vision Norway, and I'm making headway into the highest echelons of the Norwegian judicial system and into the psychological system, and that will shock Norway when it comes. But I think you, with your factual analytical basis, need to have meetings with the Supreme Court, with the various courts in Norway. You need to set up seminars and actually gain their trust and respect, because fundamentally they're not bad people. Although I have talked with the sharpest knife in Norway's judicial drawer, Dr. Carl August Fleischer, who wrote his monumental book in 2006 called Corruption Culture in Norway, which is very shockingly accurate. Still, I think that there are so many judges and lawyers in Norway that are very hungry to learn and to rethink. And I think you have your greatest task ahead in meeting with them and helping them to understand. Thirdly and lastly, in my little comment, you said that you analyzed the southern versus the northern models. And I see that when I travel, for example, in Kosovo and Albania, Romania, Bulgaria, Hungary, and other nations, that the Norwegian model, the Nordic model, is being presented as a part of the Norwegian Norway funds package, which is like, in Norwegian terms, it's EØS money, which the EU has allowed Norway to use at our discretion, the way we want. And I know that I sit with members of parliament in Albania, in Romania and other countries, and they come here and they present us with great packages of money, of opportunity, of travel, of respect. And we need that. And then we grab it. That's something that Ordo Iuris, ADF, and other competent legal agencies need to challenge the whole system in Europe, because I think that Norway should not be allowed by the European the various courts to do this. Now that it's being proven time and time again that we're breaking the European Convention on Human Rights on vital points. So please, you've got massive work to do, Mr. Kwasniewski and your colleagues, in years to come, and I hope you will have the stamina and the strength and the money to do it.
Thank you very much for your warm words on our work and some remarks. As to the last point, 2 years ago we have published the full analysis on the Norwegian grants, Norwegian funds in Poland. That was the basis for the current government to renegotiate the structure of those funds being streamed into Poland, as they are in fact the payment for the access to the market. So should be used in a proper way, accordingly to the policy of the state and nation, not accordingly to the policy of the foreign ministry of the Kingdom of Norway, as it was presented before 2015. And yes, of course, those all are very important issues, especially while we are working together to implement this now affirmed by the European Court of Human Rights, the proper model of foster care and child protection services that reassure the priority of the biological family and the best interest of the child, strongly connected with the need to reunificate the child from the foster care to the biological family. Let's have a 10 minutes coffee break, and after the coffee break we will go back to the panel, this time asking all the lawyers here to participate and to take part in the panel of experts. Thank you very much.